Okay. So today's week 2, right?
Yeah, and I know that's strange because there's 2 holidays this week, and we started on Thursday last week. Um,
Oh, okay.
but those are,
Last week, Thursday last week?
yes, that was the official start date according to the governor of
Okay.
New York.
Because
So,
last week is hard for me to log in. Last week, the Wi-Fi, so much things to do, need to fix. Oh,
yeah, I understand. Yeah, that's one of the reasons why I don't have hard deadlines, especially in the first 6 weeks, because
first 6 weeks.
because I assume people are gonna get behind, and so it's okay. But to be blunt, one student who's on this call is pretty far ahead, so you're also allowed to get ahead. Um, so kind of just structure it the way that feels best for you. Um, so I'm starting.
Okay.
I'm starting today with this is kind of related to kind of how to do this work because this class is going to be different than other classes, um, and part of the reason why I teach the class differently is because the concepts are different. This is not a class where you can just memorize things and understand legal reasoning. Part of that is because this class is usually offered to junior level students, so there's a bunch of knowledge that we assume that you have. At Kingsborough, we're offering it for you all so that you don't have to take it later and you get kind of the foundational knowledge you need for criminal justice. So I put in here this kind of cartoon to start off with because this is the funny part, basically, of thinking about lawyers, judges, and what legal reasoning is that this lady, as she's a witness stand, says, how come only lawyers get to object? This means something. I'm going to say this carefully. There is no good reason. Okay, so there's reasons, and there's reasons that law professors will give you, and those will be different than what lawyers give you, and those will be different than what judges get you. But this is largely an American construct. So if you go to Italy, for example, and you watch court cases, it's not the case that only lawyers get to object. In fact, judges are very interactive with the process and ask the witnesses questions, they ask the defendant questions. And so you see there's different legal systems depending on where you are in the world. That's also true within the United States. There's different legal systems depending on where you're at in the United States. So probably some of you are aware of the Texas situation with abortion services. A situation like that would be impossible in New York. And that's because of the New York legislature. The Texas legislature this year alone has, not only banned abortion, but to allow citizens to essentially spy on each other, which is interesting because that case will be ruled unconstitutional by courts in Texas because it violates Lawrence versus Texas, right? So Texas has done this before. This is not the first time Texas has tried this. But they've also outlawed voting. So Texas has made lots of rules that don't really make sense to New Yorkers, and they don't make sense to people from California, but they do make sense to people from Tennessee. And so this is one of those challenges because rules are different depending on which social group you're involved in. And that's why this cartoon kind of captures this moment, is that people are uncomfortable sometimes with the legal structure because it's not a memorizing kind of thing. There's not one set of rules, there's not one set of values, there's hundreds of different rules and values. And so if I just kind of start with that idea, is that you have to get out of the mentality of that there's only two sides to a story. There is many more than two sides to a story when you're thinking about legal reasoning. And so, good morning, David. Now I got the chat box is now right in my way. So there's more than two sides, and you have to start thinking about this differently then. It's no longer about he said, or she said. It's now more about the structure. So you have to think about the biggest structure that we usually study, which you should have studied in your United States government class, either in high school or here at Kingsborough or somewhere else. And the structure already creates two types of identities. There are those people who are the rulers, and generally you think of those people as congressmen, courts, judges, lawyers, corrections officers, cops, business people. You tend to think about people that way, right? Because they're constituted, they're created that way as rulers. They get to create the rules and enforce the rules. But then there's also the subjects. Those are the people who, in general, are the people who are following the rules. And that gets complicated because we want to believe that those people are following the rules, but they don't always follow the rules. And so one kind of simple way to think about it is who gets to make the rules. People who get to make the rules generally don't follow those rules. They made those rules for other people. And then so who gets to enforce the rules? Well, those people are usually stuck in the middle. So a lot of people are angry with cops right now, but they haven't studied the judges that gave the cops the power to do what they do. And so if they knew the judges were creating the structure, they'd say, okay, I'd rather protest in front of judges instead of cops. And so this is a complicated structure that exists in the United States when it comes to laws, legal enforcement, and law following. So you have to think about who gets excluded by the rules, who was never thought about. Famously, if you look at the Constitution, women were not included at all in thinking about the rules. So when people say something like, the Constitution expresses the will of the people, well, people in that case is defined as landowning white men. And so anyone who is not a landowning white and Christian man at that time, Jews and Catholics were excluded from that process, as were Muslims. And so it was only a very specific set of people who had the ability to make rules, enforce the rules, and then they excluded people from those rules. So you always want to think about who's being excluded from the rulemaking process. Then there's people who are, if you can believe it, outside of the rules. The most common experience today, this has not always been the case, but over the last 20 years it's been the case, is undocumented people. They're called illegal by some people, but that is a contradiction. It doesn't make any sense. You can't be a legal person. That's not a thing. That doesn't exist in the world. So you're being excluded by the rules. You're not allowed to participate in making who gets to be a citizen and who not. And so now you're pushed outside of the rules. So you're affected by the rules, but you have no way of participating in that rulemaking structure. And so that makes it more convenient for people to say things like illegal, because then you can just say, well, that person doesn't exist. They don't count. It's not morally correct, in my opinion, and it's also legally completely wrong. You won't hear lawyers talking about that at all. You'll hear people on the media and politicians talking about it. Then you have to think about who's harmed by the rules, because people are consistently harmed by the rules over the last 250 years. I'll give you a hint. The people who are excluded by the rules and who are outside of the rules are always harmed by the rules. People who have figured out how to assimilate or who have been accepted, a good book or article or video you could watch is How Irish Folks Became White in the early 1900s. Those people have been harmed by the rules but have lessened the harm largely through protesting, striking. The civil rights movement is another example. So it takes large social groups to organize in order to become a part of the rulemaking process. So those are the questions you kind of want to ask every time you're doing a reading, every time you're thinking about writing something about law. You really need to think about these things before you make any general statements. And then you really, even after you do that, you have to identify the contradictions. This is hard for a lot of students to do at first because you're not used to doing it. Contradictions in this sense means things that are contradictory within the structure. And because we have a structure that separates rulers from subjects, there's going to be contradictions. Ordinarily, in your US government class, you call that separation of powers, you call that checks and balances, sometimes you call that sovereignty, and other times you'll call that, there's pluralism. There's lots of different names that a textbook would give for this process, but it's just showing the contradictions. The easy way to think about this is what are the gaps between rules or laws as ideal, and that's what's really happening to people. So when somebody gets shot and they're unarmed by an armed police officer, that's a contradiction. That's not supposed to be allowed according to the rules as ideals. And so you have to go back to those questions to see, well, how did this structure create that contradiction? And so you want to avoid broad generalizations. You want to try to stay away from big sweeping comments of people are bad or this law is good. You don't want to say things like that because that's not really what we do in law. That's better for people on TV and for some politicians. The other hard thing for students to deal with in this class is that there's never going to be a one resolution that's going to solve every problem. In fact, that's not even a goal of law. Judges never try to resolve every conflict. They're only trying to present one possible resolution among many. And you really should see that, for those of you in the legal system class, you should really see that in Judge Downing in Anderson County, the case where he's trying to figure out, here are my options, and what choice is the best choice within these options that I've been given. And those options are always brought by the prosecutor, the defender, the plaintiff, or the defendant in the case. So those aren't things that judges can just make up. They have to use the materials that have been given to them. And so you just got to get out of this habit of thinking there's going to be one law that's going to solve every problem, or one rule that's going to solve every problem. And at best, there's going to be a pause in the conflict, meaning that at some point, there will be a way for those two people or those two groups of people who are having a conflict, sometimes a violent conflict, they'll be separated or they'll be paused. And in theory, the rule that will come out of that case will help us think about, well, how can we keep those groups from fighting again? But that's only theoretical. That's not practical. There's not a real rule that says you're no longer ever going to be able to harm that other person. A good example would be domestic violence. You can go to the courthouse. You can file a piece of paper and get a temporary restraining order saying that that other person cannot come within 150 feet of you, or you can even, negotiate those details. But that piece of paper is not going to stop the person from violating that rule. Just like the law saying that you can't hit people didn't stop the person from hitting somebody. And so these are just pauses. These create little reminders or little structures that, when in the best case scenario, they'll work, but oftentimes they don't work. So the next thing is you just have to slow down. This is not a class where you want to go quickly. This is a class where you need to take your time and really probably have to reread things several times. This is not something that you can just read once and you're totally going to get it. I had a student email me about the reading about the early slave cases, La Amistad. Those should be confusing because the stories that we hear and the stories that we learned don't really come from those legal cases. So the idea...
Yeah.
Go ahead.
Sorry, not to interrupt you.
No, perfect.
I'm confused. While reading it, I was very confused, but I had to slowly, break down the text, I guess, to understand.
And this would be a good time to pause because, I'm really trying to get this chat screen out of the way, but, think about this. Why is it not, I think there is a movie actually, but why is there no social media, short video, or a meme, or why didn't you learn in elementary school that there were judges who said that slaves had the right to kill their masters on board slave ships? How come that story never was included, do you think? Anissa.
I didn't know you were asking. I guess because it's hard to break it down, in words. I don't know.
Well, I broke it down pretty quickly, right?
Yeah.
But what makes me different is I went to law school. So these are legal cases, right? So unless you're a lawyer, unless you're a judge, unless you're a law professor, why would you ever read this case? Right? I mean, you don't go to the grocery store, and they've got a picture on the wall saying, on Thursday, starring Judge Joseph Story. You know, you're gonna learn about the Amistad case, right? So the information that kind of travels is not the information that is generally found in a law book, right, or a legal case. And so part of this learning process that you have to go through, where you're going to be confused, is this clash between what you've heard from non-lawyers and what you're now learning from lawyers. And so, for example, this is a great time to do this. There's no such thing as a landmark case. It's one of my biggest pet peeves. It's something that the media talks about. You'll even find textbooks talk about it. But, I mean, first of all, a landmark. I mean, I'm curious in this generation. Does anybody know what a landmark is? Anybody? I'm going to guess from your silence, no. Because we don't use this phrase anymore. A landmark is a phrase that responds to people who are on a ship in the ocean and you see land. So I have no idea how people started using this metaphor for legal cases, which have absolutely nothing to do with navigation or being in the ocean or geography. And I don't even think Google Maps uses this term anymore. So I have no idea what people mean when they say this. I interpret what I think they're trying to come across as they think it's an important case. The sad part is most of the cases that are called landmark cases aren't very important. So Texas versus Lawrence, for example, people call that a landmark case, but it did not stop the courts or the politicians or the police officers in Texas from continuing to violate those laws and those civil rights. And so I just have no idea, other than, having something fun to say in a textbook. I've also seen like chili peppers in textbooks and saying this issue is hot. I also don't understand that. The important point here is that this just is not the way that lawyers speak, and so it's not helpful to think about those kind of common media type representations. There's also no such thing as a loophole. A loophole is that thing that exists in your shoelaces when you tie your shoes. And that has nothing to do with law. People usually mean when they say this that they disagree with the moral decision. So they think somebody should have been punished, the person wasn't punished, and so they disagree morally. They don't know anything about the judicial process. They don't know anything about the law. They didn't study the criminal issues or the civil issues. They just don't like the outcome of the case. So it's kind of like their opinion on what the outcome was. They're not really commenting about anything about the legal system. And so that's another word that you have to try to just stay away from. The other issue is that this is also very hard. If you're following legal cases in the media, and I'll use the abortion case in Texas again. The judges in that decision, they didn't make a decision. That's number one. They actually did not make a decision. So when the media says that they sided for Texas or they did this or that, that's incorrect. They didn't do anything. And you can have all sorts of political opinions about whether they should have done something. And in fact, if you read Justice Sotomayor's opinion in that case, she's dissenting. She's saying they should have made a decision. But even the majority in that case that decided not to hear the case, they said they didn't want to hear the case because they're pretty sure that the Texas courts are going to find the law unconstitutional. So it's not their place. So that should be ringing in your head. That's separation of powers. They're saying it's not the job of the federal court system to tell Texas to stop misbehaving. That's Texas. Texas needs to deal with their own problem, because you don't want New York, right? We don't, as New Yorkers, we don't want Florida telling us that we shouldn't wear masks or that we shouldn't get vaccinated, right? We don't want Florida making our decisions for us because they don't have anything to do with us, other than the fact that lots of people go down there and sit on the beach. So you have to try to separate. I would say just don't even pay attention to the media when it comes to legal cases. I would also say don't pay attention to the media at all, just for your own mental health. But sometimes you're required to in some of your classes. The other issue then that I'm really trying to get at here is that legal cases have unique language and usage. That's why you have to slow down. The idea here is that each reading I give you, social science reading, and each legal case I give you, you need to study the language and how they're using the language. The Anderson case with Judge Downing is a good example because he explains a lot of that language. You'll also see a lot of the language explained in the Ginsburg reading and the Law and Identity Reader. You also need to think about the context. So the two big contexts that you really have to understand this class to do well is the concept of federalism. So if you look at this image here, there's a lot going on. So this would be one of those things that you're going to watch this on YouTube. You're going to take a screenshot right now and study this. But this is in a nutshell. I made this for students over the last couple of semesters because I understood when they were telling me this is probably the hardest concept to understand. You've got a definition of federalism in your previous classes that doesn't really quite explain anything. It's one of those, you memorize it, you get an A on the test, but you didn't really understand what it meant. So basically, there's like 3 levels, you know that, right? So there's the state, the local, the state, and the federal government. And that's the simplest way of thinking about it. So, if you get a ticket because you were spitting or you crossed in the subway cars, you're going to go to your local court. You're not going to go to federal court, and you're not going to the state court. I mean, hopefully, right? That would be a terrible situation if they were charging you with a felony. But if you punch somebody in the face, you might go to state court or you might go to federal court, depending on how severe their injuries were. So those different levels hear different types of cases or different types of situations. But there's also levels within those levels, and this is where it gets super confusing. So you probably know that you can sometimes appeal a case. You can't appeal cases in every situation. But if the judge makes a mistake at the lowest court, then you can appeal to the next court, and that's called the appellate court. And then if there's disagreement between the two courts, the first court, the trial court, and the appellate court, then you can appeal to the highest court. And so the Supreme Court doesn't hear very many cases, and the New York Court of Appeals doesn't hear many cases, because there has to be a disagreement between judges, not a disagreement between parties. So it doesn't matter if the defendant disagrees with the judge. The judge would have had to make some mistake within the law, and that's what the next level of judges is going to review. Essentially, they're kind of punishing or consequencing or reviewing the judge. Now, the other issue is this one called conflict of laws, and that's what you have learned or will learn in this class as judicial review. And so if Texas passes a law that violates or conflicts with other laws, including ones that are in Texas, the Texas Constitution and the United States Constitution, and other federal cases, now that's going to be a review for judges. They're not reviewing other judges' decisions, they're reviewing the legislature's decisions. And in some cases, they'll review decisions that happen in public settings, so like the school system, in the MTA system, in the public healthcare system, and in very limited cases, not very many, they'll review private businesses. But that's a very complicated thing, and that doesn't happen very often. One case, if you're interested, you could look up, is the one that Attorney General Letitia James brought against Amazon. That is a great case for showing you both federalism and the conflict of laws. Amazon violated a number of laws in New York, and she's a good lawyer. She played the game very well and got that case brought in federal and state court because she knew there was going to be some conflict of laws issues. And so this is kind of why you have to slow down, is that a lot of what you've learned about the legal system, especially in an intro to American government class, is just too simplified and it's not very accurate. And then you get mixed messages in the media, social media and television, entertainment. And so you kind of have to try to get rid of those thoughts if you want to do well in this class. And then the language and the usage is just brand new for you. So it's a lot like learning, I think it's a lot like learning a new language. And so if you kind of thought about it the same way, you should make flashcards, try and think about phrases that you'd use if you were at like a dinner or a lunch with somebody and you wanted to talk like a lawyer. And then these two big, huge concepts, federalism and conflict of laws, they're gonna repeat in every single case you see. Are there any questions on that part at all?
So far, I think it's okay.
So we got one, we're good. How is everybody else?
Yeah, you and him. Everything is okay.
Okay. I mean, right now I'm just kind of pointing out the challenges and then how you're going to go to the next level. This is the one that's probably the hardest, but I don't expect you to be able to do this until after the midterm and hopefully by the final. And I'm going to be an easy grader when it comes to this process because it's hard. Judges and lawyers use a unique style of reasoning that's different than a lot of your classes. Now, what's interesting to me is that this process is also used in your biology class. So if you can do well in this class, you should also do well in science classes. The idea here is that, and there's a difference between the science classes and the judges, but when a judge gets a case, they've gone to law school. In many cases, they've practiced being lawyers. Not in all cases, but in many cases. So they're used to using legal language, and they're used to thinking about legal rules. And many of us, if you brought us an issue, we'd immediately think of a few cases in our head. We'd say, oh, this is just like that case from 1886, or this is just like that case from 1999. And that's because we've read all these cases, right? And we've read probably hundreds, if not thousands of cases over the years. And obviously, the older you are, the more cases you've read. So anytime, let me give you an example. A sociology professor friend of mine and a student of his wanted to talk to me because this student wanted to see if he should go to law school in order to find out how to bring a legal case against the state of New Jersey, because they, in some places in New Jersey, they don't allow businesses to be open on Sunday. And I listened to the reasons why the person wanted to do this and why they thought this was an important issue. And I said, I don't think this is a legal issue. This is a political issue. So you need to get people together, you need to protest, and you need to try to get the government in New Jersey to change their mind about the law they passed. But I knew from reading previous cases that there would be a good reason why they weren't open on Sunday. And in those places, the majority of those populations passed a local law based on their religious beliefs. And as you probably know, the First Amendment says that you can do that. You can pass laws in your local community that are in concert or in agreement with how you think your community should be governed or ruled. And we have lots of examples like that in New York City. If you go to an Islamic school, they have different rules than if you go to a Jewish school. We celebrate certain holidays and we don't acknowledge others. And so this is a complicated area of the law, but it almost never applies to whether somebody is going to be forced to open their business on Sunday. And so the reason I knew the answer to this question is because judges and lawyers, we don't use politics, or at least the good ones. The Stormy Daniels, a lawyer, would not be a good example. We use previous cases. So we'd say to the person, well, in cases like the one that you're describing, this is what judges have said. And so it's very unlikely that judges are going to say something different than what all of the previous judges had said. And so that's what we mean by a legal rule. And so we always start with a legal rule. What is the legal rule? So people get very confused. And one example we'll look at in this class from a different point of view is Brown versus Board of Education. Students and ordinary people who are not lawyers take that case and they say, oh, segregation is illegal. That is not what the court said. The court agreed with Thurgood Marshall, the lawyer, that separation is not equal. But that is not the same thing as saying inequality is illegal. There's tons of inequality in the world. That is not illegal, according to the Supreme Court. What was illegal was using state money to forcibly separate children. So right now, the United States is more segregated than it was in 1950, meaning there are more white kids that go to white-only schools than there were in 1950. The difference now is that the method that the government and Congress tried to use was busing. So now they require busing to try to make schools more diverse. But what happened after the 1950s is something called white flight. A bunch of white people left the cities and moved into white-only suburbs. And they get away with that because you're allowed to have what are called restrictive covenants in the law that helps you define what you want your community to be. Like we said about you don't want your businesses to be open on Sunday, you're allowed to come up with those laws because this is now about private property. So in public settings, you're not allowed to have forced separation. But in private settings, if you come to my house, I can separate you however I want because it's my house. You probably wouldn't want to come to my house if I was separating people, and that's kind of the political point. So Brown versus Board of Education just essentially said legally that you can't use state money, you can't use taxpayer dollars to forcibly separate children. And so people are trying to figure out now, well, how do you attack diversity or how do you attack critical race theory or all of these things that have now become ways of getting at the inequality problem because they were successful in the past. And this is the difference between the politics and the law. So the way we use this reasoning is we say these two things all the time. We say like in these cases. So, one good example that I saw in a draft so far is understanding that Downing in the Anderson cases uses Lawrence v. Texas. And he says it is like this case, the one he's dealing with. There are usually anywhere from 10 to 20 cases that a judge or a lawyer would cite to when they're using this language. You probably only need to use 1, 2, 3, 4 I think would be a lot. You'd be doing a lawyer-like job if you were using 4 cases. First-year law students usually use about 3. The more important thing here is you really want to get into the habit of unlike these cases. And unlike these cases, you want to show me that you understand the difference between the cases. And so this will usually involve your simple descriptions. So, if you learned that federalism was separation of powers, which they're not the same thing, but if you learned that in a class and they gave you an A for saying that, you'd want to say, well, federalism and sovereignty don't apply in this situation because of this case. This case helps us better understand. And a hint there would be Marbury versus Madison. Sovereignty is not as much of the issue as federalism is in that case. And so you'd want to compare that case to a Lawrence versus Texas case because they have very different definitions of what sovereignty is and what federalism is. So the next level is that you have to, once you kind of understand the rules of cases and how you're going to put those together, and again, remember, there's not one rule. So you're kind of picking the rules that you think make the most sense, and then you're comparing those to rules that you basically disagree with. You don't think that those rules apply. Then you have to deal with the case facts. Then you look at, well, what's going on in this case? So, in the case of Anderson County, the legal facts that are agreed upon is that 2 people of the same sex went to go get a marriage license, and the person that was supposed to sign the piece of paper said, no, I'm not going to do it. So the legal facts are not that there are 2 people that wanted to get married of the same sex. That is not the legal fact. The legal fact is that the person who had the job to sign the marriage certificate said no, they're not going to do their job. And so they bring the case to ask the judge, basically, doesn't this person have to do their job? And that's going to be the similar situation in the Texas abortion situation, is that somebody has to bring a case saying they basically got ratted on by their neighbor for getting an abortion. And isn't it the job of the court to keep people's privacy protected? If you read that Anderson case and the Lawrence case closely, you'll say, of course. In Lawrence, Texas, it said very clearly that your right to privacy is guaranteed by the Constitution. So any violation of your right to privacy is something that you can bring to a judge. And that's the legal agreed upon fact, right? That's the thing that you'd be trying to figure out. Any other details that you'd be used, that's your application. And that's going to help you make the conclusion. And that's where you say something like, well, in this case, this is a clear example of violating the legal rule. Or you'd say, in this case, it's not so clear. Maybe it's not evident that there was a legal rule that was violated. I'm going to say that carefully because students, this usually hurts your heart. And this pulls up your moral side. And your moral side comes out. And that's good. That's great. And you should understand that a lot of the time, your morals and your heart are going to disagree with legal logic. And that's okay. But you want to say that next. You want to say the legal ruling is this, but I wish that there was a law that said this, or I wish the judges would say this. And that kind of shows that unlike these cases situation. Because usually judges are not ruling on morals. They're ruling on the process and procedures of law. And so it's more about, did the police officer read somebody their rights before they started asking them questions about whether they committed the crime? Did the police officer touch the person before they had reasonable suspicion to touch them? And these are the individual facts that you'd be analyzing, because if those two things occurred, then they'd be violating the Fourth Amendment. And so this is what you want to kind of think about. And then just remember, there can always be more than one rule. You'll want to start with identifying one rule, but there could be 3, 4, 5 rules. Try not to get these confused. And I would avoid, probably in a 3-page paper, I wouldn't try to list a bunch of rules. I would probably just stick to one rule. And for the legal system class, for your definition of sovereignty, you kind of have to find a legal rule that fits with your social, what you believe sovereignty should be. So if you think that sovereignty should be with the majority of the people, you need to find a legal case and a social science reading that supports that idea. I'll tell you this, Anderson County does not stand for the idea that sovereignty should lie with the majority of the people. So that would be a bad example to use, but you could say unlike Anderson and unlike Texas. In those two cases, they're protecting the minority from the majority. The majority is harming the minority. And so those two cases have judges that are saying the minority needs to be protected. So that's much more like a monarchy. That's much more saying, the law is supreme, or their application and interpretation of the law is supreme. And so those minorities need to be protected. That's very different than saying that the majority of the people have expressed their will in the Constitution. And remember that that's not technically correct, right? Because it was a minority of landowning white Christian men who wrote the Constitution. And so the Constitution does not represent the express will of the majority population today, which is why a lot of people argue that we need a new Constitution, and I would agree. The other issue, that's the last thing I'll speak about, is there's always going to be conflicting cases and interpretations. And so it's good for you to recognize that and include that in your paper and in your answers, especially on the midterm and the final. Understand that your interpretation is not the interpretation. It's not the only one. There's always going to be 12, 20, 30. I mean, there could be hundreds of interpretations of the same thing. One kind of social science experiment you could do is to take an object, any object. It could be a plant, it could be your cell phone, it could be a TV show, you push pause, and have everybody in the room look at that object and do it pretty quickly, like maybe less than 5 or 6 seconds. And then have everybody close their eyes and write down what they think they saw. And what you'll find is everybody will have a slightly different definition and a slightly different picture in their head of what they think they saw. In other words, everybody has a different interpretation of the same thing that everybody was looking at. And if that's as simple as just looking at a one object, imagine how complicated that would be when you're trying to think about legal cases and the he said, she said situation that happens, and you're never sure if everybody's telling the truth, right? And so judges and lawyers are usually doing the best they can at trying to get to as close to a similar representation of the same thing, but they're never going to get to the one and only. And so you have to try to think about it that way. So on the right-hand side, I've given you kind of 5 boxes that show you how to complicate your simple descriptions to start to think like a judge. So once you kind of review the New York Court website, where it gives you that basic information that sadly some people charge you $100 in a textbook for, even though it's free, is just what is the court system? What are the procedures? What are the roles? Many of you are probably familiar with this because you probably watch TV shows. And those are accurate, right? I mean, they have a judge, they have lawyers, they have witnesses, they have parties that are defendants and prosecution or plaintiff. And so you're pretty familiar with that. But I do want you to look on that website about the complexity. You know, where do you bring a case? If you bring a divorce case, where does that happen? If you bring a domestic violence case, where does that happen? If you bring a case where you were assaulted, but you sustained injuries that were less than $500 worth, where does that case go? And where does the case go if you're summoned because you didn't pay your taxes to the governor? You'll see that those procedures will be different. There's not one system that deals with everything. And so even the way you file a case will be different depending on where you go. A very good one for you all to look at is the small claims court. Just in case you ever want to, somebody steals $500 from you, somebody, a lot of times, let me give you another example that's really more common. Somebody says you owe them money from a credit card, or from a retail store, or from a utility, or from a some internet transaction that you made, and you paid them. And they say, yeah, but you didn't pay the interest, you didn't pay the penalties, blah, blah, blah. You know, all these things they'll say. They want more of your money. You can go to small claims court and defend yourself. You can win. You don't have to pay them money. It's in my early years, I would go up to the Bronx and help out with these cases and watch them, largely because I had it happen to me. And I wanted people to know that, no, you can defend yourself. There are legal procedures that defend you. And most of the time, those people are lying. And sometimes they don't even know they're lying. Sometimes they think they're doing the right thing, but they didn't really look carefully at the contract that you signed. They're just trying to get what they can from you. And so that would be a good place for you to see just what are the procedures and what roles are available to you. There's a lot of resources. There's free lawyers that will help you. There's a court clerk that can help you. And then from there, you'll have enough understanding to understand what it is the judges are doing and how they're using these procedures and roles in making decisions. Then we have to complicate reality, right? Because not every issue gets into the public court system. And so this is where we'll start to look at injustice topics. We'll look at the limits of judges, what they can and can't do, how they don't really influence society in a lot of cases. And we'll think about how people think about rights. It's a strange thing to say, so I'll say it again. We'll think about how people think about rights, because that informs the processes that people take in their everyday life. A very good example of that is the DeLand article that you'll read that talks about how we construct rules by playing with each other. They use the example of pickup basketball. To be blunt with you, I used to play street ball, and so I thought this was a good example, and it's easier for me to explain to students. But I've heard from students that even if you don't know anything about sports, this is still a good example, because you see how people kind of make up rules as they go, how they think about punishment, and how they think about enforcement, which are all things that we're doing in this class. The other article gets to the Black Lives Matter movement and how you kind of start to understand, hopefully, that movement, and it's similar to many movements before, and that's what the article is showing you, is that Civil disobedience becomes necessary when laws are unjust. And you know laws are unjust when they're producing abuses of power. I've done ride-alongs with police officers who tell me that they're usually confused in these situations because they get mixed signals. They hear things from politicians, they hear things from the chain of the command, they hear things from their friends, they hear things on social media, and so they're never really 100% sure when they have probable cause or when they have reasonable suspicion or when they're in imminent danger. And so if a system is producing that kind of confusion for first responders, people on the ground, then that's a clear abuse of power. And the police are abusing their power, but that power was given to them or made available to them by Congress, by judges, and by society at large. And so you need to start to see how that experience is what constructs these resistances. And that's what tells us how to think about rights. And then finally, you're going to practice being like a judge. And I'm really looking at you practicing the process of being a judge, not the content. So I'm not expecting you to be an expert on law. I'm hoping that you'll start to get through this process of abductive reasoning. Again, I will be a fair and relaxed grader on that. I just want to see that you're trying to identify legal rules, that you're trying to identify the legal facts, and then applying those legal rules to the facts. Hopefully you come to the right conclusion, meaning the legal conclusion, but that will be less important than just trying to work with the legal rules and the facts. The last thing is you really have to think about differences that make a difference. So in other words, you want to be identifying differences in this class. So what's different in this reading? What's different in this case? What's different in this video that I've made? And why does that matter? And the hint there is that it's all about how we interpret the law, how we interpret cases, and how that makes a difference in the way that we behave. People have different expectations about what they think the law is, and that influences how they behave. Once they have something negative happen to them, so for example, there was a recent article that showed that among white folks who were surveyed about the BLM movement, for those who had never had a